Act that amends the third schedule of the Income Tax Act by introducing new bands, and these are matters that we do not consider unconstitutional. We've also looked at Section 33 of the VAT Act that introduces VAT on insurance compensation. We find that it does not violate Article 40, and it is not unconstitutional. We have looked at Sections 30 to 38 of the Finance Act, which amends Sections 5, 8, 12, 17, 34, 30, 34, 43, first schedule, second schedule of the VAT Act, and we do not find them in violation of the Constitution. We also looked at Section 48 of the Finance Act, which amends Sections 2, 20, 28, and 14, first and second schedule of the Excise Duty Act, and by introducing Section 36(1)A and 36(a), and we do not find them unconstitutional. And we also have looked at the changes in tariff headings and rates under the Excise Duty Act, and we do not find them unconstitutional. And we find that the introduction of the housing levy amendment to Section 84 lacks a comprehensive legal framework in violation of Article 10, 201, 2010 of the Constitution. That levy against persons in formal employment to the exclusion of other non-formal income earners without justification is discriminatory and irrational and arbitrarily and in violation of Section Articles 27, 201, B1 of the Constitution. And flowing from those findings, we find as follows that, and these are our declarations, Section 76 to 78 of the Finance Act, amending Section 7 of the Roads Board Act, 87, amending Section 28 of the Unclaimed Assets Act, Section 88 and 89, repealing Section 29 of the Statutory Instruments Act, are unconstitutional, null and void. That Section 84 of the Finance Act violates Article 10, 2BC, 27, and 201 of the Constitution and is therefore null and void. That an order is granted prohibiting the respondents from collecting, charging, or otherwise the charge known as the Affordable Housing Act on the basis of the Section 84, and all prayers on the consolidated petition not specifically granted are dismissed, and this being a matter of public interest litigation, each party shall bear its own costs. And we thank all of you, all the counsels who appeared before us, all the litigants who appeared before us, members of the public for keeping a keen eye on this matter, and we thank you all. It is part of your responsibility as citizens of our beloved country. Thank you. Yes.
Please, to my judges, first and foremost, I wish to thank you very much on behalf of all the colleagues who are here. 160 pages of a judgment was not a mean feat, and especially the reasoning we have actually gone through. Let's not comment now, because each side is having some joy, others are a little bit aggrieved. But on behalf of the third and fourth respondents, allow me kindly to confirm that we are aggrieved by the findings as regards the Kenya Roads Board, Section 76 and 78, the Unclaimed Assets Act, the Statutory Instruments Act, and especially regulations thereunder, which possibly are in force today but may expire if that order is enforced, some of which are on revenue-raising measures, and Section 84 of the Finance Act, in which the housing levy has been declared unconstitutional, and a declaratory order has been made to stop the respondents from collecting the levies. Allow me to apply for a stay or a conservatory order for 45 days. In those 45 days, I urge you to suspend the operation of those particular findings in the judgment and any decree that may flow therefrom, pending the filing of a formal application under Rule 32.2 of the Mutunga rules, as they are popularly known, and eventually under Rule 5 2B of the Court of Appeal rules. The justification is as follows.
Could you go over that again, please?
Yes.
You're asking for?
A stay or a conservatory order for 45 days as regards the portions of the decision that has aggrieved the respondents, and in particular, it is a Kenya Roads Board, Section 76 and 78, the Unclaimed Assets Act, and the Statutory Instruments Act amendments, which have been declared unconstitutional. Also, Section 84 of the Finance Act, which has been declared unconstitutional as regards the housing levy, and an order as fraud therefrom, stopping the respondents from collecting the housing levy. So the reasons why we ask you for this is, first and foremost, especially for the housing levy, we have to make the necessary adjustments to the government procedure of taxation so that no party, no arm of government, no officer of the government is sued for contempt. Because that has been allowed as for now, while it is in the public domain that in fact the levy is being collected as we speak. There may be also irreversible loss, and especially if on appeal this section is upheld. Because the reason is that this is a consumption tax. It's money that is being spent to exactly do what the amended Act states, which is to try and put up housing for citizens. There would be actually no prejudice on the part of everybody who has paid housing levy. This is because, as the Court of Appeal observed in its ruling hearing, civil application number E304 of 2023, any party aggrieved by payment to the government of these levies can actually get rebates for overpaid taxes and levies. So those applications can be made and monies possibly will be refunded. Now, we also have another reason why we ask you for this, which is serious irreversible economic consequences in the operation of the arms of government, and especially when it comes to affordable housing. It is vitally important that this is preserved for a while as the government considers the next alternative after appeal or rectifying the law, the flaws in the law, as the court has identified. That in fact, there may be nothing wrong with the taxation itself. It's only that we do not have in place proper laws that are supposed to guide the policy. Therefore, with those remarks, I do pray that you grant a stay or a conservatory order for only 45 days, by which time the respondents will have taken a decision on how best to move, either to the Court of Appeal or to have enacted the proper legislation. Thank you.
Thank you. No, we deal with the respondents first. Kenya Revenue. Please introduce your name for the record.
For the record, I'm Mr. Ochin Gaya. I appear for the Kenya Revenue Authority. My Lord, on behalf of the Kenya Revenue Authority, we would like to seek a stay of the declaration with regard to Section 84 with regard to Housing Fund, the pronouncement, which is not in the finding but is the body, as to Section 5.1 of the KRA Act, with regard to the implementation of only laws with regard to the first and second schedule, because that pronouncement places us in a very awkward situation, because we not only collect the housing fund, but there are also other agencies. So we'll be seeking that pronouncement to be stayed. Why so? One, Kenya Revenue Authority has clearly captured in the judgment had issued a system adjustment and a public notice. And this system adjustment, those hearing from the bar, we are all aware that currently the pay is being collected together with the housing fund. That system adjustment will require time for it to be readjusted. Secondly, this judgment places a Kenya Revenue Authority at a position where it will be subject to suits for illegally collected funds, and two, will need a stay order to prevent refund claims which shall be made. Why so? Kenya Revenue Authority finds itself in a position where it can only refund taxes under the statute. These are being declared to be outside the statute, where we will be subjected to damages suit. In that regard, we will be seeking that we be allowed to stay pending our formal instructions from the client on the best way forward. The petitioners will not be prejudiced in any manner, as rightly proved by learned counsel Senior Murugara, they can't claim refund from the relevant agency, which is the Ministry of Lands. They can't claim that refund from the Ministry of Lands, but we seek from our side, we don't have a mandate and a remedy on how we shall recover these taxes, should the law finally be found to be proper. In that regard, I seek that you begin a 45-day stay with regard to Section 84 and that pronouncement with regard to KRA Act Section 51.
So, Soma?
Lordship, we will also be seeking stay of the Attorney General of the Republic in the declarations made by the court for the following reasons. Your Lordship, as it relates to the declaration on the statutory instruments, it affects a plethora of regulations which we need to advise in order to comply with the very clear judgment of this court, various state agencies and government institutions on the effect that has on them. Your Lordship, as relates to Section 84 of the Finance Act, as it relates to the housing levy, we need time to advise the parent ministries on any commitments or contracts they might have entered into as it relates to the collections made under the housing levy. We understand that the court has pronounced itself. We want to comply, and we will comply with the judgment of the court.
Aya ni ndeto ria ragithie na mbere igoti-inĩ inene ria Milimani, na no wakiona ũhoro wĩgiĩ igoti ria nyũmba cia raithi. Igoti-inĩ rĩaregana na ndeto ĩyo, na anyiti itemi magĩtiganĩte nĩo magĩkinyĩtie kũu KRA na honge ciothe cia thirikari. Koguo Mũkenya nĩ igoti-inĩ rĩaregana na igoti rĩa kuongererwo kwa mbeca iria thirikari ĩrabatiĩ gũkorwo ĩkĩũngania cia nyũmba cia raithi. Nĩtũgũkorwo tũgĩcokereria mwena ũcio nĩgetha tũkũmenyithie makĩria megamaine na cira ũcio. Mau no ũndũ ũmwe wa maũndũ marĩa marakoretwo magĩtwarwo nĩ Okia Omtata akĩregana na thirikari na rĩendekithia rĩa thirikari rĩa watho wa kĩgĩna mwaka wa 2023. Twambe tũcenjie ikinya na gĩkundi gĩtarĩ gĩa gĩthirikari kĩgiĩ gĩthomo kĩa elimu bora nĩ mathiĩte igoti-inĩ na nĩgetha kũrũgamia mĩhang'o ya woyani wa arutwo arĩa mekũingĩra kĩrathi-inĩ gĩa form 1 nginyanagia rĩrĩa mateta megiĩ maumĩrĩra ma kĩgeranio gĩa KCPE na marĩa merĩga kũrekererio makorwo magĩetherwo kĩhonia. Gĩkundi gĩkĩ kiugĩte atĩ nĩ mahĩtia manene mũno maumĩrĩra ma kĩgeranio gĩkĩ kũgĩa na mĩhĩnga ta ĩno, kuona nĩkĩo kĩrarĩ ya gũtiriha mũtaratara wa gĩthomo wa 844. imwe kwa imwe tuigue mĩario yao ya hau kabere.
Majina yangu ni David Karani, mmoja wa elimu bora. Tarehe 23 tuliona Waziri Machogu akiweza kutangaza matokeo ya mitihani ya KCPE, mtihani ambao ulikuwa wa mwisho katika hiyo mfumo wa masomo. Na Wakenya walikuwa wanatarajia mambo mengi sana, kwa sababu vile alikuwa anavyomalizia ingewapa Wakenya hakikisho kwamba pali wanaanzia patakuwa ni pali pazuri tunapoelekea kwa mtaala wa CBC. Tuliona alitangaza kulikuwa na kesi 2 tu za udanganyifu ambazo ziliweza kushughulikiwa vizuri kwa watahiniwa wote milioni 1 ambao walifanya mtihani, 1400 candidates. Lakini kulikuwa na mshtuko ambao Wakenya walipata wakati walitangaza hii mtihani. Wakenya walikuwa wanagojea mambo mengi, lakini walipata mshtuko. Mshtuko wa kwanza ulikuwa kuchelewa kwa kupata arafa fupi ya kupata zile matokeo za wanao. Wazazi, shule wanafunzi, kuna wanafunzi ambao walipata alama ambazo hazikuwa mtihani ambao hawakuwa wamefanyia. Kama vile tunaona wale waliopata lugha ya ishara, sign language, wengi wao hawakuwa hata wamejisajili kufanya ile mitihani. Kwa hivyo walipata alama ambazo hawajajisajili kufanya. Wengine wanapewa A, wengine wanapewa B, na haieleweki walitumia njia gani kwa kuamua ama kufanya ile mambo. Ya 4 ilikuwa ripoti ambazo tunaziona kwenye runinga za shule zingine ambazo zinasema watahiniwa walipata similar results, lakini wanapata different placements in terms of grade A or B. The fifth shocker ilikuwa wakati wengine tumetegemea zaidi na tumejiweza kujikaza zaidi kuhakikisha kwamba tumepata alama nzuri. Na tunakumbuka Machogu alisema mitihani hii inaonyesha itakuwa ya huru na itakuwa ya haki ya kuonyesha bidii ile watahiniwa wameweka. Kwa hivyo tulikuwa na mambo kadhaa tulipoangalia na tukaona integrity ya mtihani wa KCPE results umekuwa compromised. Na vile kama elimu kuenda sawa. Kwamba mitihani itakuwa ya haki na ya huru, ili watahiniwa wote ambao walifanya mtihani wapate mitihani yao, wapate matokeo yao ya kweli ambayo ya true reflection of their abilities and the hard work that they've put. Vile tuliweza tuko na call of action. Our call of action ni tunamuuliza CS Machogu asimamishe hiyo mambo ambayo wanaendelea nayo ya kuchagua watahiniwa wale wanaingia kidato cha kwanza. Tunaomba kwanza hizo barua za wito waweze kuzisimamisha mpaka wakati ambapo kumaliza haya maneno na kila mtahiniwa apate haki ili waweze kupata shule pamoja. Elimu bora tumeenda kotini tayari under certificate of urgency, na hayo mambo tutakuwa tunapeleka kotini ili tuweze kupewa order ya kusimamisha hayo maneno. Na pia tunasema we want a restoration. Tunataka kuwe na hakikisho kwamba mitihani ambayo yamefanywa, mitihani ya KCSE, mitihani ya KIPSEA, mitihani yote yako sawa, kwa sababu hapo tunavyoona sasa hata Wakenya hawana imani tena na tume la mitihani. Kwa hivyo tunasema ni responsibility ya wale ambao wamepewa hii kazi, they hold duty of care. Tunasema Njegere na CEO Njegere na Professor Machogu, they have the responsibility to assure Kenyans ya kwamba mitihani hii tunaposonga mbele itakuwa ya huru na ya haki, na itaonyesha bidii ambayo mtainiwa aliweza kuweka. Ni jambo la kusikitisha sana mtainiwa anapokuwa anafanya mitihani, lakini pia anabado kuwa na wasiwasi ya matokeo ya mitihani. Kwa hivyo inakuwa ni jambo ambalo si nzuri zaidi, si nzuri hata kidogo. That we are asking that they take responsibility. Thank you.
I do advise
Nĩ ngatho mũrĩrĩ wa Kameme TV. Tũragĩthiĩ na mbere na tabarĩra ya Ndurumeni Matuura-ini. Macio no mamwe ma marĩa marathiĩ na mbere makĩhanĩkaga mũthenya wa ũmũthĩ, na ngũririkanie no ũthiĩ na mbere ũkĩnyandĩkagĩra kũhĩtũkĩra Facebook itũ ya Kameme TV Kenya kana yakwa mũndũ kĩũmbe ya Gĩcimo Joseph. Twambe tũikĩrie oro hanini, ndĩracokereria nĩguo tũthiĩ na mbere na kũhungura matũũra.
Kameme TV.
Identify yourself.
Listen up, ladies and gentlemen.
Oya mzito. Wewe, hebu kam nikuplug. Niko na ile kitu imebamba kila mtu kutoka Maslay Queen wote hadi wazae. Hii kitu ni noma kuruka. Kitu kali itakupeleka dunia ingine. Hii stuff ni kama magic. Ni wewe tu umebaki mse. Hapa utaweza kuexperience EPL yote. Magame haziwezi kupita, na pia unaweza pata ma statistics manze. Na bado kuna ma movies, series, soaps, cartoons na documentaries. Na kama wewe ni msichana like ma podcast, live radio, DJ mixes na hata live television, hapa uko sorted. Na unajua ni aje? Ni sare. Ni sare kabisa. Download the K24 Plus app upate free premium shows bila kesi.
Stream premium content popote ulipo. K24 Plus. Come nikuplug. The year is 2023. The day. Kiumia mweri thato Dithemba Korea Gashie Primary School. Kameme kayo kamo ige na Kameme TV. Tunyitanire na Thomas Moinami.
Wenewe Ngai utadisappointaga.
Turakurehera Gospel Explosion 2023. Ekarubione Moigai wa Joroge Ben Gethai Lois Kim Shiro